In this video, we're going to be talking about relocation and child custody in Indiana. So ultimately, if you have some kind of custody order through a divorce, paternity, or child custody case, we're going to be talking about when you can relocate with your child, what you need to do, and then what kind of court process may or may not be involved in this kind of situation. So about me, my name's Nathan Vining. I am a criminal defense and family law attorney in Indiana, and I help people with child custody disputes throughout the state. Hopefully by the end of this video, more about the relocation rules in Indiana. So we're going to be talking about how relocation works in an Indiana family law case. And the first thing that's important to know is when you actually need to file a notice of relocation. Generally, you have to keep the opposing party in a case apprised of your address and where you reside at all times. However, there are certain instances where you need court approval to do a relocation and certain instances where you do not need court approval. But just as a general rule, you need to ask the court to get approval for the relocation. And it's such a big deal because if you're involved in a custody case and you have a child's parent that wants to move somewhere like Tennessee, Florida, or to the West Coast, it can really impact the time you can see your child as well as your rights to parent your child, make decisions, and just be present in your child's daily life. So this is a very important topic, and we're going to talk a little bit more about it. So just as a general rule, you should always provide notice to the court and other parent of relocation, and you need to request permission of the court in a lot of instances. But there are times where you don't need the court's approval, and that's when you are proposing a relocation that actually decreases the distance between you and the other party, as well as if you do a relocation and it doesn't increase how far apart you guys live by more than 20 miles. In those instances, you would not need to file with the court and actually get permission to relocate with the child. So if you do need to provide notice under these relocation statutes, the first thing you would do is you would need to file a notice of intent to relocate. The next slide is going to talk about what that notice needs to include. But ultimately, you need to provide that notice 30 days before the planned move. It's important to know the non-relocating parent can object, and they have 20 days after to file that objection. And then ultimately, the court will hold a hearing and hear evidence and determine whether or not they're going to grant the relocation request or not. The notice, it basically has to provide a lot of very basic things. It's the date of the planned move, where the new address would be, any new phone numbers that would be applicable, an explanation for the proposed move, if it's going to be a move of a great distance, any proposed revisions to the visitation schedule, and then a statement that the non-relocating party may object. And it's important, you want to prove that they actually got this notice, so you want to serve it via certified mail and keep the documents from the post office. You can actually prove when they got the mail and that they were served with a document. And you also should file the same with the court, just to keep the court up to date with your most recent address. So ultimately, if the court holds a hearing on a relocation, there's a lot of things they would look into. They would look into basically how far away the proposed move is and what kind of hardship that could put on the non-relocating parent. They also would look into the feasibility of preserving relationships, which kind of goes hand in hand with that first one. A lot of times when I'm talking to somebody that's dealing with a relocation case, I like to think of it like the courts try to keep the same amount of parenting time. So if somebody has 50-50 parenting time, it's a lot harder to move because it's going to be harder to preserve that same quality relationship, because you can't kind of keep roughly a 50-50 schedule if there's parenting with distance as a factor. But if there's more of the guideline parenting schedule, it is possible to keep the same amount of overnights where the person has parenting time over the summer breaks, holidays, and keep the same amount of overnights, they're just shifted around in the month. Or for instance, sometimes they would have 1 week in a month in all summer. There's a lot of ways, if it's not a 50-50 schedule, where a party could feasibly argue that the relationship can be preserved with the same amount of time. The other thing you're going to want to look into is just the reason for the relocation. The courts will look at, is it a valid reason and why? So for instance, sometimes a person has a spouse in the military and they have to move somewhere far away. That's a factor that would give a lot of weight to a relocation because it's such a proper and valid reason to relocate. But sometimes you would see a case where somebody wants to move to Florida and it's just they want to be in the sun more, and there's no valid work reason, family reason, or other reason to go there, just it's a want and a desire. The court would look at that and weigh that accordingly. Depending on the child's age, they may also look at the child's wishes. They would look at also the other common custody factors like history of domestic violence, the physical and mental health of the parties, the child's relationships in the school, community, and with your family, and their adjustment as well. So there's a whole lot that goes into it. And ultimately, if you're facing a relocation case, it's really important to get an attorney, because an attorney can basically, no matter which side of this you are on, help piece it together in a way that advocates for your side in the best manner possible. So it's also important to know, I mean, this is area of law that families get wrong all the time. There's commonly somebody just moves, they change the school, and then after the non-relocating parent gets upset, and they're wondering, how can they do this? Did they not involve the right process? And it just creates, honestly, it kind of creates a mess for the courts and a mess for the family. That's the reason there is this process, so it's all done in a way that's predictable for the child, their relationships can be preserved, and so on and so forth. But a lot of times when I get involved in a case, it's because a spouse relocated without contacting the other parent, notifying the court or anything, and then suddenly there's a parent that's not getting the same amount of parenting time as they were. They're not able to maybe coach sports like they used to and things like that. So what happens, and a lot of times like that, is the statute allows you to get a temporary restraining order. And this essentially prevents a parent from relocating with a child. So what I would do is file a motion for a temporary restraining order, an emergency return for return of the child. And a lot of times the court would then order the child be returned, reside with the other parent, stay in the same school until there can be a hearing. And that's oftentimes what will happen if a parent doesn't follow the right relocation process. The next thing, I talked about this a little, is if parents do relocate, a lot of times people can make agreements to what happens in the situation, and oftentimes it is best to reach agreements in family court, do it through mediation or just a settlement conference with the other parent. But one of the common things you see is when somebody resides out of state is a parenting schedule known as parenting time when distance is a major factor. And this is a lot like the Indiana parenting time guidelines. The guidelines are a model that show what a typical, or at least the minimum parenting time would be for a parent in Indiana. There's also a model for what parenting time should be when there's distance in a relationship. So if two parents live in different states. And this schedule, I'll put it in the show notes, but ultimately it's where the child would go to the non-relocating parent during an extended school break, and that gives them quite a bit of time with the non-relocating parent, still allowing that relocating parent to move for whatever those needs were that they filed the relocation notice for. So that's something, if you are looking to learn about what you can do in a relocation situation, definitely check out the parenting time when distance is a major factor and the schedule associated with that. It's also important to know that one of the common you would be aware anytime you actually travel to the area where the child resides, because the court wants you to be able to travel and see the child, and if you're there, for the child to be made available for you in that instance. So hopefully that gave you a little bit of an overview about relocation and child custody in Indiana. If you have questions, or you're dealing with a situation where you have a parent that relocated with a child and you believe that your rights may have been impacted and your relationships being damaged, give me a call. I'd be happy to review the evidence. Or on the inverse, if you are contemplating relocation and you need to know and strategize on how to best do it, give me a call or text me. I have forms you can fill out on my website to contact me or set up a consultation phone. I'm pretty findable. So thanks for watching, and I appreciate your time. And here's my number for you, so call, text. I'd be happy to help.